All right.
Our group, Damiana, Stephanie, Dolores, and Jennifer, will be discussing the legal landmines associated with the distribution of religious material on school campuses by public school students, the Equal Access Act and its impact on schools, clubs, communities, and along with the precedents that have been set related to equal access as it relates most specifically to religion, and how these precedents should impact administrative practices within public schools.
Legal landmines associated with the distribution of religious material on school campuses by public school students. Student distribution of religious material is protected by the First Amendment Free Speech Clause, subject to reasonable time, place, and manner regulations instituted by the school. Generally, student distribution of religious material is acceptable if it does not cause a disruption. Public school officials themselves may not distribute religious material to school children. Students generally have a right to distribute religious material in public schools. However, school officials may apply reasonable time, place, and manner restrictions as long as the restrictions are narrowly tailored to achieve the school's educational objectives.
I want to add something in here. I want to jump real quick. You mentioned something about us being, public officials. We are public, and we don't want to get involved in the, violation of the First Amendment. I wonder, if a teacher would be talking to us students outside school, probably off campus, and would suggest something like that. Do you agree with me, ladies? Is would that be a violation of the establishment or the freedom of religion? And if we can go ahead and do that, I found it an interesting question, right?
I think that outside of school hours, even though you're still looked at as a teacher for the school or a public school employee, I think that you would have to be careful. But I think that you still have your rights also. So I think that you would be able to, express the freedom of religion. So I feel like you should be able to within our country. In Hedges versus Wakanda Community Unit School District, the court ruled that the junior high school could apply reasonable restrictions on the students' distribution of religious materials by implementing policy that limits when and how students could pass out the written materials. The court ruled that the junior high school in this particular case was a limited public forum, and so therefore they could implement a policy when and how they could pass out the materials as long as those restrictions were not arbitrary or whimsical. And as an example of those reasonable restrictions, the court said that could include setting up a special table for distribution or to limit the time when they actually could be distributed.
And in that case, what was interesting is that the courts also said that the placement of the table is important, because in this case, they had the placement of the table in front of the entrance of the school, and the court said that looked like a sign of school sponsorship. So the actual thought of where the table can be and where they are allowed to pass out has to be kept in thought.
Jennifer, I found it interesting. I never thought about that. If a school would have the table up in the front versus somewhere else, it's kind of interesting to me. What about during lunch? It's the limitation. I do agree with the limitation. We have for every other rule, every other right, it has to be limited. But the position of the table, I found it fascinating, really, that if it's in the front, then the school is actually really facilitating that. That's interesting.
I thought so too.
Yeah, I did too. And as an administrator, before this, I would have never even considered, knowing that, that you could provide a place, but knowing that the location makes a difference, that's something that was surprising to me. I would have never even really considered that before.
Well, but when you think about it, if you're casually driving by and you see a table in front of the entrance, your automatic thought is, oh, this is something the school is putting out. Right. So I can kind of see it.
Yeah, I can see it now, but I would not have considered it before. So, in another case, Mueller versus Jefferson Lighthouse School, a student was refused permission to distribute school invitations to a religious meeting by the school. The court there upheld a restriction requiring prior approval of non-school materials before they could be distributed to students, so long as that approval was not granted solely on the religious nature of the material. The court questioned whether the restriction was reasonable or not, and they considered in light of the grade school environment, that noting that an elementary school under its custodial responsibilities may restrict such speech that could crush a child's sense of self-worth.
This is really, really amazing. It's like how the Supreme Court is looking at our youngsters as elementary school different than other, high school. And the interesting part about this case is actually they didn't talk about the establishment clause as in other cases. So, and here it's like, okay, when it comes to to elementary school, we have to be very careful of and we have to approve. So you have to submit your request, and you have to show what you're going to be talking about. As a parent, I kind of understand that, because I really want to know what's going on in school and what kind of materials you're distributing to my students, to my kids, sorry. And that's kind of true at this young age. They're going to be absorbing everything, and they're not ready to actually make their own opinion, or to have their own opinion and be able to comprehend and analyze what they're hearing. Interesting.
And I'd like to say, as an educator, now that we're learning all these laws, I feel more empowered, because the office will send down documents. Oh, put these in the kids' folders. Mm-hmm. And you really understand that line now as to what can go home and what cannot go home. And I see this even being classroom issues with parents wanting to send things home that are going on in their church, and maybe they want to let the kids in the class know about Vacation Bible School or something like that.
But at the same time, I kind of disagree on that. As an administrator, I would be really, really, you're walking a really thin line, because you have to read it and you have to approve it. And, the person who wanted to distribute that material, he may disagree with that. And then where are we going to go with that? It's the word to approve is kind of really, it's not narrow. It's really huge. I mean, to approve what? And I didn't see a Supreme Court decision that actually clarify more to the approval part. And I kind of feel we have kind of a violation of the establishment clause, if you agree with me, because I'm saying, okay, this is not okay. So if it kind of it's a really fine line in here, unlike again in high school, in which it's kind of broad.
I think I agree with that. I also wanted to point out that in Johnson's Loiner versus O'Brien, that was difficult to say, prior approval of religious literature cannot be used to single out or prohibit specifically religious materials. In that court, they stated that a ban on all student religious speech clearly inhibits religion, and thus violates the Establishment Clause, forbidding the government from obstructing religion. So we have to be careful as educators that we're trying to stay right in the middle of that. I mean, we don't want to go to the left or to the right. You have to stay right in the center.
Well, and what I thought was interesting when I was doing my research is that the courts have failed to define what religion is, what constitutes a religion and what doesn't. And so having that thought and having something that's brought to you, like Damiana said, that fine line of what is a religion and what you can pass out is very blurred.
And wait for this, ladies. So we talked about, having the table up in the front of the school. And then we talked about that fine line for elementary schools. And now we have another case. It's Westfield High School. And in that case, it's a federal court case, a district court, sorry, in Massachusetts. It went further, and it's actually holding that such restriction need to contain safeguards, such as a requirement that the school administrators review, and it has to be done in a reasonable short time. So what is that? Define that, right? And that such reviews must contain narrow, objective, and reasonable standards. Yeah, I got it, right? So it's again, it's really broad. It's really hard for me to, as an admin or administrator, it's really, really hard for me to understand what goes in the approval and what doesn't.
Well, and in that case, what was interesting is that what the issue was is that there were some girls who was passing out candy canes with the religious story behind the origin of the candy canes. And they were denied to pass them out because it was ruled offensive. And so the court said that they had to reword policies and put in procedural safeguards so that the opinions of the administrator, wouldn't happen again. And I thought that was interesting. And in the same thing, we've been talking about this entire time, that Henry versus the School Board of Colorado Springs School District just upheld that school policy can restrict a student to outside of the building to pass out religious publications. In this one, students were just passing out stuff to their friends in the hallway and in between passing classes. And so the court said not to do it inside the school camp. On school campus, it has to be outside of the school building. So
I just want to point out that I feel like this is another one where we as administrators, we have to think ahead, like see into the future and have those policies that follow the law, but that are already set in place. So that way there is no where we're determining, is this okay or is this not okay? We have policy and procedure there for us. So, I mean, if we're able to think ahead and have that set, then there's not quite as much consideration, where you were saying objective and reasonable standards. If it's already there, then you look, like at the different criteria, yes or no.
I agree. And I've seen in some instances where now schools have they have a site-based management or a committee where all clubs have to come through that committee, not come through, but it's part of the submission process. Well, talking about high schools, I've seen lately that yoga has quickly become popular, even among high school students, and many schools are now receiving grants to implement contemplative practices like yoga to improve motivation and to assist in self-regulated learning. However, in the case of Sedlock versus Baird Encinitas Unified School District in San Diego, where plaintiff parents claimed that the yoga taught in schools was religious and therefore unconstitutional. Yoga was provided by trained instructors from the Joy Foundation twice a week as part of the health and wellness program in the district. And the Superior Court Judge John S. Meyer ruled that the district's program passes constitutionally and is exercise, not religious indoctrination. And out of this, you've seen a spring of yoga clubs created by students. And I went to a website, a blog that high school students who were running the yoga club at their school, they broke down how they created the club, and they said they initiated the club themselves. They made sure that was in the wording. They distributed the materials, and that the responsibility of the school was to ensure to students, parents, and community that the club did follow the guidelines and the rules. And they advertised with posters and flyers that were approved by the administration, and then their meetings were held after school in the band room. The founders invited yoga instructors from outside the school. However, this group chose to teach yoga as a form of exercise, and they avoided religious language and metaphysical explanations. And I would like to just extend what your thoughts on it were. I'm sorry, I'd like to extend on what your thoughts would be if they added religious language and metaphysical explanations.
Well, I think that, okay, sorry, can y'all hear me? Okay. When as you were going through and you were talking about yoga, it made me think of the moment of silence and how they can pray or they can meditate, or so when I think of yoga, I don't really think of religion. I really do think of exercise, and I think of a meditation, but I didn't really think of religion being considered part of yoga.
Yeah, I agree with you, and this is my thinking too. And I think probably Jennifer mentioned that we don't have a definition for religion to start with. That's one. Another thing, I found it fascinating because I was thinking about proposing something from my principle, because I am against ISS the way it's being, implemented in schools. I really don't like it. And in one schools, I believe it's in New York, they're actually they take the students because they feel that the student is actually stressed out, and that they needed to relax, to breathe, and they actually hired yoga instructor to come to the school, and instead of sending the students to an ISS, they would go for 30 minutes session, and it would relaxes them. And they were reporting about great improvement when it comes to discipline. And we all know discipline goes hand in hand with learning. So like you said, Stephanie, I would never think about yoga as a religion, and at the same time it's oh my gosh, it's what our professor was saying is you're taking this class, hopefully you're gonna keep your name out of court cases, but you can see how easy it is for you to go and be part of that.
Well, we just started a yoga club here at our elementary school, and I was talking with one of my paraprofessionals that works with me, and she has heard lots of people say that yoga is against their religion, because when you do yoga, you're supposed to clear your mind. And when you clear your mind, that's the perfect time for the devil to come in and tell you things to do. And they think it's hard to know if it's the devil telling you what to do or if it's God telling you what to do. So in some people's religion, having a clear mind is not a good thing.
That is interesting. I've never thought of that before. That was something that would have never even crossed my mind. It just would have never crossed my mind.
Some programs, in order to have permission to have the programs in the school, they have to leave out some of the Hindu references to the religious part and focus more on the breathing and the exercise.
It's good to know. Yeah, I would even never think about that. Yeah. All right. I'm gonna try to kind of summarize what we've been talking about, ladies. Okay, we have the since schools are generally considered limited public forum. And because we have kind of the First Amendment rights of the students are not as extensive as or equal to those of adults, especially like us, right? Schools may prohibit distribution of certain types of literature altogether. And additionally, of course, we have, the U.S. Department of Education, that they issued actually a general guidelines to kind of help us. From our conversation, we are frustrated. We are kind of confused on a lot of stuff. So they're trying to actually have a general guidelines regarding the distribution of religious materials. And I'm quoting, students have the right to distribute religious literature to their schoolmates on the same terms as they are permitted to distribute other literature that is unrelated to school curriculum or activities, which is, of course, going to bring us to the next question about, the Equal Access Act. Schools may also impose some limitation. It does make sense, you can't interfere with school activities whenever you feel like it. And it has to be like in reasonable time, a certain time, like you said, not in the front of the school. Remember that, ladies. A manner and other constitutional restrictions or distribution of religious literature as they do on non-school literature in general. But they may not single out, of course, religious literature for special regulation. So it's again, it's going to bring us to the next point. It's like, okay, you cannot restrict things because they are religious, if you will. School may impose the same reasonable time, like I said, and it's kind of like they're trying to give us like some clear guidelines that goes with all the things that we discussed, ladies, and in relation to the decisions of the Supreme Court cases and other courts cases. And religious literature cannot be singled out for regulations. So if you're going to have regulation, it has to go for everybody. And courts are less tolerant, and we kind of like touched base a little bit on that. I found it like really interesting. We are more tolerant toward high school. It's more the Supreme Court is like more broad, and I know that Tinker is considered like a freedom of speech case, but it's also applied here in preserving the First Amendment, because when you talk about religion, these clubs, it's like your freedom of speech is being on stake as well. And the court focused on the importance of preparing high school students. So regarding the high school, we are like more conservative when it comes to elementary, and we talked about it. But when it comes to high school, it's different, because it's important for us to prepare high school students to become like productive citizens, and thereby allowing them to develop the ability, I'm quoting, to understand and comment on the society in which they live, and to develop their own sets of values and belief. And I kind of like see that in elementary school, it's really hard for the students to figure that out. At the high school, yeah, we kind of like, we wanted them to do so. Even when dealing with high school students, court will still uphold reasonable time, still, place, and manner restrictions, as long as those restrictions are applied equally to all written materials.
That sounds like it leads us right into the Equal Access Act. Jennifer, would you like to introduce the Equal Access Act?
Of course I can. The Equal Access is just a federal legislature that was signed by President Reagan. It basically tells us that, I'm sorry, hold on just a second, that if a school allows a curricular group to meet at that school, then it has to allow every non-curricular group. So the school media can be used to advertise the meetings. They can restrict the time, the place, and require rules to maintain the order. They can deny access to any organization that promotes violence, hate, and illegal drug use. If a school or district policy is not complied with, they can deny use. What I thought that was interesting that Damiana talked about earlier is that it only speaks of secondary schools. And what I found out was that when it was debated in Congress, they thought that young children wouldn't be able to initiate and lead groups. So they're also more likely to see groups offered at schools as being sponsored by the schools, which I thought was interesting. So Congress declined to add the elementary school in there. But in the Good News Club versus Milford Central School, the court ruled that the elementary school violated the free speech rights of the club by denying them access to school grounds for weekly after-school meetings. So I found it interesting that even though elementary school is not covered by the Equal Access Act, that it still goes against the First Amendment rights. And so, I don't know, I don't know how to say it. It's really weird that they're not in there, but they still have to do it. Does that make sense? Like the kids aren't going to initiate it, but they can still have them held there. I guess what I'm trying to say.
Yeah, I understand. I'm sorry. Go ahead, Damian.
Okay, I want to add that it's very important to point at regarding the Equal Access Act that it's actually going to bring us into a different topic. It's not only about religion versus non-religion people, which I truly believe in equality, and we have to give each a forum equally. But it's actually going to bring us to an essential in litigation regarding the right of students to form gay and straight alliances. So again, let's go back to the same question: what is the definition for religion? Would that be part of it, right? So I think the schools are up to a lot of challenging when it comes to the respectfully to gay and straight alliances in schools.
I want to go back and because I have it quoted here about the Equal Access Act. It's found in Title 20 of the U.S. Code, Section 4071. And it specifically states that the restriction of limited open forum on the basis of religious, political, philosophical, or other speech content is prohibited. And quoted from it, it says, "It shall be unlawful for any public secondary school which receives federal financial assistance and which has a limited open forum to deny equal access or a fair opportunity to or discriminate against any student who wishes to conduct a meeting within that limited open forum on the basis of the religious, political, philosophical, or other content of the speech at such meetings." So I think where we were talking earlier, we have to understand that once we create a limited open forum, that then we have to provide that for everyone. That's what the Equal Access Act is saying, is that once it's there, it can't be limited by what you think or feel.
Yeah, I agree with that, but it's really it's kind of like if we want to look at the Equal Access Act, it talks about, just in case you get the money. So here we go again with the funding, kind of like the previous chapters that we talked about, other laws. They hook you with the financial aid that they give you as being the federal government, that is. And at the same time, it's like the only way to get away from all this is actually not to have any forums at all. And of course, it's not feasible. And in our days, you have to have clubs. You have to have and to include absolutely everybody. So if we're going to read the Equal Access Act really carefully, they're not telling us that we have to have it. So it's really up to the principal, I guess, or the district to decide on that. But of course, I don't know of any school that prohibit, any, clubs or any after school activity or stuff like that. So just
question for you two are at the high school level.
Yes.
How is the message put out for parents and students at your school regarding clubs or initiating clubs and their rights?
Well, I think that all we have is we have our school district policies and procedures, and we have our student handbook that they receive. And that's pretty much it. We are such a small school here that we really don't have student initiated clubs. I mean, for the most part, all of our clubs or all of our organizations or meetings that we have are generally academic or curriculum related.
I found it interesting, and I shared that in previous conversation with Stephanie, is like I always try to connect with my kids and try to ask them. I'm in a high school setting, and most of the population is like African American. And when I ask them, okay, let's think about something that can help you. What do you think the school should provide you with? What other things beside the clubs that we have around here? And most of them, they mention something about religion. It's like, can you have somebody to come and talk to us like the word of God? And I found it fascinating, really. and it's like something that the student wanted. But at the same time, you are so limited by the, the freedom of religion and the establishment clause, even though it can help some of the kids and they wanted that, but you cannot provide it because you are a public official and you cannot, cross that line. So it's kind of like the sugar cane. I mean, like how innocent that can be, you know what I mean? And I think it's like it becomes like too much, I think, and it's taking the fun of a lot of stuff, and part of it's like Christmas and decoration and gifts and re-gift and all that stuff. So I don't know, but still, as administrator, we have to be careful with these things, unfortunately.
Okay, let's take a look at the how the statute, it defines limited open forum as when a public secondary school grants an offering to or opportunity for one or more non-curriculum related student groups to meet on school premises during non-instructional time. The statute requires schools to offer a fair opportunity, where you were talking about equal access, to students who wish to conduct a meeting within its limited open forum if such school uniformly provides that. The number one, the meeting is voluntary and student initiated, as you all had mentioned. There is no sponsorship of the meeting by the school, the government, or its agents or employees. Employees or agents of the school or government are present at religious meetings only in a non-participatory capacity. The meeting does not materially and substantially interfere with the orderly conduct of education activities within the school, and non-school persons may not direct, conduct, control, or regularly attend activities of student groups.
As I think back in high school, I was a member of the FCA. I don't know if y'all know that, but it was Fellowship of Christian Athletes. And I remember being an officer, and I never understood why we had a teacher there, but all they would do was sit in the back. I found it very weird, and it didn't click until I read this. It was like, that's the reason why we had to lead everything. And I think our teacher failed to tell us why, because I think our students need to be educated. There's a line that teachers can't cross. And Damiana, you were talking about not being able to tell your students that they can initiate it, but my question is, why not? I mean, if it's the law and we are there to educate, why is it not okay to tell our students, well, according to state law or federal law, you can initiate it and you can lead a group, but why can't we tell them?
See, I was thinking that if we tell them, if we overhear them talking about something that they want to do, and we as an adult in their life that has a great deal of influence on them, if we tell them that your group can be student initiated, I feel like that's leading them that way. And so I'm afraid that might get us into trouble just because of the fact that we point out, hey, you can start a group. I mean, I feel like that might be a bit of a dangerous ground.
I would possibly just direct them back to their student handbook and take them to that specific area just to share the policies.
Right.
And not saying yes or no, but just showing them what the regulations are.
Because a very important part of the Equal Access Act is that the groups have to be student initiated and they have to not be sponsored by the school. In the Good News Club versus Milford Central School, the U.S. Supreme Court held that an outside religious club could meet at an elementary school after school hours because the school permitted other non-religious groups to meet at the same time. And there was no perceived endorsement of the club's religious activity. And although Good News concerned an elementary school, the free speech and religious endorsement principles in that case, there should be applicable to both middle school and secondary school context.
And that's interesting, is like, what if you have a school that is considered like, where you have you have 5th and 6th in one school building, and then you have the high school start from the 11 and 12. So interesting. I'm not sure I read that in any of the cases, the definition of a high school age? Is it by age? Is it by grade level? That's interesting question, I think. Yeah.
Secondary, I know, is defined as 9 through 12. So I know secondary is 9 through 12. I'm not sure what the definition for middle school is.
Yeah, interesting.
Well, and then my question goes is that there was another case. I'm going to talk about it in a little bit on one of our other questions, but it talked about college and about establishing a religious group in college. I kind of take it as in we are college students and our professor is teaching us that we can initiate. And even though she's telling us she's not sponsoring us in any way. So I don't know. For me, it's more of a blurry line of why not. And I get your point, Stephanie, that it's like we're sponsoring it. But then again, knowledge is power. It's not I'm sponsoring and I'm saying it's okay for you to create a Bible group or anything like that. I'm just letting you know, according to law, you have that right because you have a right to speech.
Here in Jersey City, some of the schools are pre-K through 8th grade. And I can see that as a challenge for that principal, having to separate information or separate the elementary students from the higher grades, upper grades. And how do you deal with the information that's going out to these students?
Yeah, what about a student that he was not promoted to the other level, and he's kind of like in the middle? So what do you consider that? There is a lot of questions to be asked, and it's a lot of things, a lot of issues, and sometimes I would tell myself, okay, let's forget about all these programs, but at the same time, I don't think it's feasible. We have to go with it, I guess, and try to have a lawyer next to us, right? To consult with with the lawyer of the district all the time before we make any decision, just in case. I'm still thinking about that table up in the front of the school is like, oh my gosh, I would never ever, and the yoga example, the case, right? It's like I would never think about such a thing, or the brain is going to be like, ready for the devil or God. And what God are we talking about? What devil, right? So it's a lot of things, but we as admin, it's good to know. I think it's good information, and we have to be careful.
Do we want to move on to any other precedents that have been set as it relates to equal access to religion? Are you guys ready to move on to that section?
Yeah, I can see like we have the club that it's called the Fayette County, Kentucky. There's a group of students who wanted to start a Black Lives Matter club at the high school. And the club's purpose is to promote diversity and promote expression and have a safe place to voice opinion. The club is open to all students, and the membership was presented actually many nationalities, and it sponsored many positive events to foster understanding and shed light on justice. However, the school board received a lot of complaints from parents, and the principal wrote a letter to the public explaining the development of the club and how the students, this is a right of a student, and we have to respect that. And he did include that, although he doesn't support all that, but still he needs to approve or to support them because of the Equal Access Act as well.
I think that, I'm sorry, go ahead, Jennifer.
No, you go ahead, Stephanie.
I was going to say, as administrators, that's going to be our biggest issue, is you're going to have students that once they understand these rights and what they can do and the clubs they can create, or you have communities that there's going to be backlash from both sides. And I feel like as an administrator, knowing the law is what's going to protect us, knowing, what we can do, regardless of how we personally feel about whatever the situation is. I think that knowing the law and being able to say, well, this is what, our U.S. Government has said, like, this is how we handle this situation, even though our community might be for or against it, or it might cause a big uproar in our school. I feel like we have to, for the for the democracy of our country. Like that, we have to support that.
And this group actually, they did go before a site-based committee, and which entailed working with staff. They even met with the University of Kentucky professor to help them develop this club, and it was student initiated. And a lot of people were very upset because of what was going on in the nation, and they associated this club with possibly the violence that was happening with Black Lives Matter. And the act does say you cannot judge that club based on what another club is doing. And I believe it is true. We are going to have to take a look at our own bias as administrators and really put them in check.
Yeah,
because if we hold true to the school vision or the mission statement that says this community will provide an equal opportunity to all children, then we will be held to the fire. I believe you'll be challenged.
We can't hear you.
Can you hear me?
Yes.
Okay, I wanted to add a really good point, which is we're going to have something in here as admin. School retain disciplinary control. And that's a good thing. At least we have, something in control, right? The act emphasized the authority of the school, quote, to maintain order and discipline on school premises, to protect the well-being of students and faculty, and to assure that attendance of students at meeting is voluntary. So at least, if something is gonna, like what you were saying, Elliot, is with the issues going on, the police, issue with the community, the Black community, and Black Lives Matter. I see it really hard to separate the issues, and the students gonna bring it to the table. I wonder if they gonna have like the opportunity to have a demonstration in which they're gonna wear certain clothes and just hold their hands up, and what kind of feeling you're gonna have in the school. Would that interfere with the well-being of the rest of the community and the school inside your school? So yeah, I see that challenge. I really do. And it's again, we need a lawyer to go with every decision.
Well, I think that kind of takes you back to the Tinker case, because that was about a group of students who were wearing a black armband, and they suspended them not because it caused a disturbance, but because they thought it would cause a disturbance. And so that goes back to that. You can't make a decision based on what could happen. You have to make the decision based on what is happening at this moment.
That's a good point, Jennifer. I think that we've had we've talked quite a bit about the different precedent, even that relates to religion. Is there anything that anyone would like to specifically say about precedent that you found that relates equal access to religion specifically?
Actually, I do. I found something that was extremely interesting. It was oh my goodness, I don't even know how to pronounce this name. HSU versus Roslyn Union Free School District. I thought it was interesting that they allowed the students to conduct a Bible club after school, but the students wanted their officer to be a professing Christian. And so the school said, no, that is against our policy. You cannot discriminate based on religion. What was taken to court, and the court determined that the group can preserve their religious content of speech. And so that there are some exemptions that religious groups can have so that they can still express their beliefs. I found it extremely interesting that the court let them do that.
But this was that case, do you remember if it was a club that was outside of school hours? I mean, yes. So it was like a Bible club or Christian club? Is that what you said? It was Christian club?
Yes, it was a Bible club after school.
Okay, so if it's outside of school hours, it seems to me whatever they determine in that club that's their responsibility. I mean, that's
Correct.
within theirs.
But like I said earlier, they are also bound to school and board policy. And so one of their policies was
Okay.
that you can't discriminate based on religion.
Oh, okay. Okay, I
So
understand.
they were seeing, but the thing is, they weren't. They were just, I wouldn't say discriminating. They wanted their officials to be professing Christians.
Right.
And so the school counted that as discrimination, and the court said no, because they're still expressing their beliefs.
Well, and I mean, to me, it just seems logical that if you have a Bible club that you would want, I mean, that your officers, the leaders of that club would be professing Christian. I mean, I don't know, that makes sense. But I also can see the school side of it as, no, that's discriminatory. So I really can see there's lots of blurred lines in this.
Mm-hmm.
So with that note, we're going to move on to how do we, now that we've had time to talk about all this, how do we think that administrators of public school, how should these precedents really impact that? And I think we've really talked a lot as we've gone through this chat that we've had. But I think my biggest point is what I've come to understand is that it's a very fine line. That as an administrator or a teacher or anything in the public school, you have to be very careful to even present the appearance of establishing or encouraging a religious belief, and allow equal access for all student groups. Although we do have some authority, I mean, if it causes a disruption in our school, or if we can establish a reasonable place and time and manner for these different meetings, and we have to make sure that they're non-discriminatory, which is like the case that Jennifer was just talking about, and neutral in viewpoint, like from an administrator point of view. So as an administrator, I think the biggest thing that I've learned going through here is that I'm going to have to be very careful to be neutral and working with others to create policy and procedures that guide our schools as a whole, and to make sure that, particularly concerning student clubs, that we make sure that we ensure the students' right to free speech, while also at the same time avoiding the endorsement of religion, which would be a violation of the Establishment Clause.
I can say that after learning about these laws, even now being careful, like I'm a Southerner, so if someone sneezes, you say bless you or God bless you. And even now, one time a student said, well, which God are you talking about? And that really put me in check. And I'm very aware of even little things like that, how that could be taken out of context.
I had the same situation. I've had students that will ask, "Are you Christian? Are you?" And I refrain. I don't answer their questions about it. Just to keep that line clear for myself. Like that's my, and I'll tell them that's my personal or my private life. It's very difficult because as a Christian, you want to share your beliefs. You want to, but you can't.
Well, one thing I found that just floored me is that a lot of these cases we talked about and we looked up deal with the same issues. So it's funny to me that do school districts not keep up what's happening in other states? Because a lot of the decisions are the same thing, and they happen within a couple of years of each other. So it just, as an administrator, you need to keep up with current court cases to make sure you don't make the same mistake that someone else did and cost your district money.
Presidents require administration to establish a culture of equality and fairness that guarantees school rights to protect the well-being of students and faculty. Schools across the U.S. face challenges regarding their school calendar, holidays, and excused absences. The Supreme Court has let stand a lower federal court decision stating that recognition of holidays may be constitutional if the purpose is to provide secular instruction about religious traditions rather than to promote the particular religion involved. And that's from the case Flory versus Sioux Falls School District, 8th Circuit. And I'm saying that as I live in New Jersey, and it is quite a diverse city. I'm in Jersey City. And in New Jersey, the State Board of Education approved a list of 100 holidays for 2016-2017 school year. Students celebrating those holidays must present a written excuse signed by a parent or guardian, and schools are required to provide students the opportunity to make up any tests or other assessments that they miss. And some of the faiths that are now, their holidays are now on the New Jersey calendars are the Buddhist, Hindu, Eastern Orthodox, Christian, Jewish, Christian, Wiccan, Jain, Sikh, Baha'i, Church of God, Philadelphia, and Jehovah's Witness.
That is amazing to me. I'm sorry to interrupt, but that is amazing to me that there are that many days, holidays set aside. There's only 356 days in a calendar year. And so, I mean, when you think, I mean, that just seems like such a large amount of time. I want to now go and look and see what for, is that just, it's the State Board of Education. So is that just for New Jersey? So I would need to go and look up for the Texas, see what ours is. Wow.
I think, Stephanie, actually, we have a law in regarding to different religion. It's not on our calendar as a district, but if a students wanted to go and observe a holiday,
right?
And like she said, they will actually report or like fill out a form or something like that, something from their parents, and we do the same thing, but it's not on our calendar. So it's the law would give them the time to go and celebrate. And that includes that travel time as well. And the law is very specific about that. I found it interesting that you have it on your calendar, though, versus us, only you can go ahead, celebrate it, and the teacher will have to give you more time to make up your work. Interesting.
And the First Amendment's free exercise clause would seem to require a reasonable number of excused absences for such religious observance as the decision in Church of God versus Amarillo Independent School District.
I'm gonna go ahead and kind of like try to help us find a guidelines, I guess, through all this mess, I guess. Okay, overall, the trend appears to be in the direction of carefully crafted allowances of such distribution. So as we were talking, we kind of like have these kind of set of questions as an admin we should start asking ourselves before making decisions. I think these questions are gonna kind of like summit all the decisions. First question, we have to consider what type of material is to be distributed. For example, Bible or religious information, flyers. Second question, who is doing the distribution? Is it a student? Is it a teacher? Is it an outside group? Are we sponsoring that group? Third one would be, what is the time and location of the distribution in relation to classroom instruction? Next question would be important to consider is what is the grade level? And we talked about the difference between high school versus elementary school. Again, the grade level of targeted students. And next one would be we have to be careful and address does the distribution pose a reasonable foreseeable risk of substantial disruption? And does the school allow distribution of corresponding non-religious materials? So if we're giving it to one group, we have to go ahead and make sure we're going to give it to the other. In some, the advice, beside having your legal counsel next to you, I guess, ready on the phone, the advice and assistance of school districts' legal counsel, guided and inspired by the decisions rendered in all of the above mentioned precedent combined should be the basis of any decision as an admin regarding to distribution of religious materials, or lack, therefore, of any public school campus. And like you said, it's really hard to keep up with the new decisions, with the developing decisions in the Supreme Court. Today, we're still waiting on a new justice. I don't know if we're going to get a conservative justice or it's going to be like more liberal. So the decision may kind of like, and we have another issue, which is, you know, the legal rights for the gay, lesbian, and different sexual groups as well. So that's
Right.
Yeah.
I was actually thinking that, like, here at the end, that I bet for our next foreseeable future that's what's going to be our main topic of the Equal Access Act or the different legal actions that are going to occur in our next few years. I agree with that.
And I think this would conclude our meeting today. And we are at 7:35. So I think we did good.
Did we go over? It seems like a significant amount of time we've been talking.
Yeah. So I'm gonna stop the broadcast right now.
Okay.
All right.